If I asked you a simple question right now, does your will control everything you own? Most people would answer yes. I understand why they would say that. It feels logical, it feels clean, you write down your wishes, you sign the paper, and when you are gone, the paper should control everything you left behind. But that is not how the system works in the world of money, law, ownership, and estate planning. What feels fair is not what controls the outcome. What controls the outcome is structure. That is the first principle. Estate planning is not mainly about documents. It is about control, who is in control when that control changes, and how assets legally move from one person to another when you can no longer speak for yourself. Once you understand those three things, wills and trusts become much less mysterious. They are not magic papers, they are mechanisms inside a larger system, and if you misunderstand the system, you can create an outcome that is the opposite of what you intended, even if your intentions were perfectly clear in your mind. I have seen people believe that a will is the master document for their entire financial life. I have seen families assume that because a parent wrote, "Everything goes to my children," then everything must go to the children. Then the parent dies and the life insurance goes to someone else. The house goes to a surviving spouse. A retirement account goes to an old beneficiary who was never updated, and the children are shocked because they thought the will controlled it all. The will did not fail. The family misunderstood what the will could control. That is an important distinction. The law is not asking what seems right. It is not asking what the person probably meant. In most cases, it is asking a narrower and much more mechanical question. How was the asset titled? Was there a contract? Was there a beneficiary designation? Those questions matter more than most people realize. Assets move at death in only a few basic ways. Once you understand those ways, estate planning starts to make sense. The first way is by contract. Some assets pass automatically because a contract says they pass automatically. This often includes life insurance, retirement accounts payable on death bank accounts, and transfer on death investment accounts. When you name a beneficiary, you are not just making a casual note. You are creating a binding instruction inside a contract. When you die, that contract executes. The asset moves directly to the person named on the beneficiary form. It does not wait for your will. It does not ask the probate court for permission. It does not pause so the family can argue about what you probably wanted. The contract controls. This is why a beneficiary form can defeat a will every single time. If your will says your retirement account should go to your daughter, but your beneficiary form still names your former spouse, the beneficiary form wins. That may feel unfair. It may feel outdated. It may feel like a mistake, but the system is built to follow legal structure, not emotional probability. And this is why I always think in terms of systems, not wishes. A wish is not enough. A legal structure has to match the wish. The second way assets move is by title. Title means ownership structure. If an asset is jointly owned with rights of survivorship, the surviving owner usually becomes the full owner automatically. This often happens with homes owned by married couples. It can happen with joint checking accounts. It can happen with other forms of property. Again, the will does not control that transfer. The title controls. Imagine a second marriage. A person owns a house jointly with a current spouse, but in the will, that person says, "I want my share of the house to go to my child from my first marriage." Many people assume that solves the issue. It does not. If the house is titled jointly with rights of survivorship, the surviving spouse becomes the full owner when the first spouse dies. The child does not receive that share through the will because the asset never became a probate asset in the first place. The title already moved it. No one is ignoring the will. The law is simply following the ownership structure that existed before death. This is how unintended outcomes happen, not because someone had bad intentions, because the structure and the intention did not match. The third way assets move is by probate. This is the bucket most people think about when they think about a will. If an asset has no beneficiary designation, no survivorship feature, no trust ownership, and no automatic transfer mechanism, then it usually becomes a probate asset. Probate is the court-supervised process for transferring assets after death. A will controls probate assets. That sentence is the key. A will does not control everything. A will controls probate assets. If an account has a beneficiary, the beneficiary controls. If a property is titled jointly with survivorship, the title controls. If an asset is owned by a properly funded trust, the trust controls. The will only controls what is left in the probate bucket. Once you see it this way, estate planning becomes a map. Each asset is sitting in a bucket. The mistake is assuming one document covers every bucket when it does not. I think this is where many families get hurt. They believe they have a plan because they have a will, but they never review beneficiary designations. They never check title. They never ask which assets will actually pass through probate and which ones will not. Then the system runs exactly as designed, and the result feels like a betrayal. It is not a betrayal. It is a consequence of structure. Now let us look directly at the will. A will is a revocable legal document. Revocable means you can change it while you are alive and competent. But a will has no real operating power while you are alive. It does not manage your assets. It does not transfer your accounts. It does not help someone step in if you become incapacitated. It simply sits there until death. At death, it becomes relevant. Its role is to tell the probate court how you want your probate assets distributed, so a will does not avoid probate. That is another common misunderstanding. A will is often the beginning of probate. When someone dies, the will is submitted to the court. The court recognizes it. The court appoints the person responsible for carrying it out. Then the estate is administered under court supervision. That is what a will is built to do. A will can name an executor. The executor is the person responsible for carrying out the instructions in the will. This person gathers probate assets, works with the court, pays bills and taxes, and distributes what remains according to the will. Think of the executor as the administrator of the probate estate. A will can also name guardians for minor children. This is one of the most important things a will can do if you have minor children. A will is where you state who you would want to raise them if something happens to you. A trust cannot do that by itself. A beneficiary form cannot do that. Joint ownership cannot do that. The will is the place where guardianship wishes are expressed. The court still has final authority because the court has to protect the child, but your nomination in the will matters enormously. So even if someone has a trust, if they have minor children, they still need a will. That is not optional in any practical sense, but a will has limits. A will cannot override a beneficiary designation. A will cannot override joint ownership with survivorship. A will cannot avoid probate. A will does not normally reduce estate taxes. A will does not give meaningful creditor protection. And a will does not help with incapacity while you are alive. Those are not small limitations. They are the reason so many people think they have planned more than they actually have. Let me make this practical. A person dies with a will that says all assets go to the children. That same person has a life insurance policy naming a sibling. The person also owns a house jointly with a spouse. What happens? The life insurance goes to the sibling because the beneficiary contract controls. The house goes to the spouse because the title controls. The will controls only whatever probate assets remain. The children may feel confused, they may say, but the will said everything goes to us. Yes, it did. But legally, everything in the will meant everything that the will had power to control. That is a smaller universe than most people think. This is why I keep returning to the same principle. The system follows structure. The system does not follow memory. It does not follow family assumptions. It does not follow dinner table conversations. It does not follow what someone meant to update but never updated. It follows paperwork. Now let us move to trusts, because trusts are often described in a way that makes them sound either too complicated or too magical. A trust is not just a document. A trust is a legal relationship. A person called the grantor transfers property to a trustee to manage for beneficiaries. That is the basic structure. The important concept is that a trust separates legal control from beneficial enjoyment. The trustee has legal authority to manage the assets. The beneficiary receives the benefit of those assets. This separation is the reason trusts exist. They allow you to say not only who receives assets, but how, when, under what conditions, and who manages the process. That is very different from simply handing money to someone outright. Trusts are about timing, continuity, complexity, privacy, and control. They can be especially useful when you want assets managed over time, when you want to avoid a public court process, when you own property in multiple states, or when incapacity planning matters. But here is the part that must be understood. A trust only works for assets that are actually connected to it. Creating a trust document is not enough. A revocable living trust can avoid probate, but only if it is properly funded. Funding means assets are retitled into the trust or directed to flow into the trust. If you create a trust and leave your house bank accounts and investment accounts in your personal name with no beneficiary connection to the trust, you have a document, but you may not have solved the probate problem. A trust without funding is like a bridge that was designed but never built. The plan exists on paper, but nothing can travel over it. There are different types of trusts, but most families encounter two broad categories. A living trust is created during your lifetime. A testamentary trust is created inside a will and comes into existence only after death. That distinction matters. A living trust can be revocable or irrevocable. When people casually say, "I have a trust," they are usually talking about a revocable living trust. A testamentary trust, by contrast, is born out of the will. It does not exist while you are alive. It comes into being after death through the probate process. That means a testamentary trust does not avoid probate. It may provide control after death, but it does not skip the court process that creates it. This can still be valuable if someone has minor children or a young adult child who should not receive everything outright at age 18 or 22. A testamentary trust can say that assets should be held and used for health, education, maintenance, and support, then distributed later. It can phase the inheritance. It can prevent a young beneficiary from receiving too much too soon, but it is not a probate avoidance tool. It is post-death control created through probate. That is different from a revocable living trust. A revocable living trust is created while you are alive. If you are competent, you usually remain in control. You can be your own trustee. You can manage your assets. You can buy and sell property. You can amend the trust. You can revoke it. In practical terms, nothing may feel very different day to day. The difference shows up when something goes wrong. If you become incapacitated, a successor trustee can step in to manage the trust assets without the family needing to ask a court to appoint someone. That can be one of the strongest reasons to have a trust. People often think estate planning is about death. It is also about life when you can no longer manage the details yourself. If you suffer dementia, stroke, a serious illness, or another condition that prevents you from handling your finances, your family needs legal authority to act. Without the right documents, they may be frozen, accounts may be inaccessible, bills may go unpaid, property decisions may be delayed, family members may have to petition a court for guardianship or conservatorship. That process can take time. It can require medical documentation, it can involve hearings, it can add complexity during a period that is already emotionally painful. A revocable trust can reduce that friction for assets titled to the trust. The successor trustee does not have to become owner in a personal sense. They step into a role that already exists. They manage under rules already written. They continue the system that was created before the crisis. That is a different kind of control, not control from the grave in a theatrical sense. Control through thoughtful structure. A durable power of attorney is also important. In fact, I think every adult should have one. A durable financial power of attorney allows someone to act for you if you become incapacitated. It can cover assets outside the trust and many other financial matters. But powers of attorney can be questioned. Some financial institutions hesitate. Some require their own forms, some challenge older documents, some reject them altogether or delay the process. A trust works differently because the trust already owns the assets it owns. The successor trustee is not asking to act as an outsider. The successor trustee is stepping into the trust structure that can be more efficient. But a trust does not replace every other document. A comprehensive incapacity plan often includes a revocable trust, a durable financial power of attorney, a healthcare power of attorney, and an advanced directive or living will. The trust handles trust assets. The financial power of attorney handles other financial matters. The healthcare documents handle medical decisions. They work together. Estate planning is not one paper. It is a system of coordinated papers, titles, beneficiaries, and roles. Now we need to clear up several myths because myths in estate planning create expensive mistakes. The first myth is that trusts avoid taxes. Some trusts can be used in tax planning, but a revocable living trust generally does not reduce estate taxes. Why? Because you still control the assets. If you retain control, the IRS generally treats the assets as yours. That is the principle. Control and taxation are connected. If your revocable trust owns the house, but you can revoke the trust, change the trust, live in the house, and control the property. Then for tax purposes, it is still effectively yours. The trust may change administration. It does not make the estate disappear. An irrevocable trust is different. In some cases, if you give up control properly, an irrevocable trust can provide estate tax planning, asset protection, Medicaid planning, or advanced wealth transfer benefits, but there is a trade-off. You give up control. That is why irrevocable trusts are not the everyday default for every family. They are powerful tools in specific circumstances, but they are not the same as a revocable living trust. So when someone says a trust saves taxes, the correct question is, what kind of trust? The second myth is that having a trust automatically avoids probate. It does not. A properly funded revocable trust can help assets avoid probate. But if the trust is not funded, the assets may still be stuck in the probate system. The trust document alone is not magic. The structure only works if the assets are moved into it or legally directed to it. This is one of the most common failure points. People pay for a trust. They put the binder on a shelf, they feel protected, but they never retitle the house, they never align the bank accounts, they never update beneficiary designations where appropriate. Then they die, and the family discovers the trust is sitting there while assets remain outside it. That is not planning. That is paperwork without execution. The third myth is that A will controls everything. It does not. A will controls probate assets. This is so important that it has to be repeated. If an asset passes by contract, the contract controls. If an asset passes by title, the title controls. If an asset is already in a trust, the trust controls. The will controls what remains in probate. The fourth myth is that a testamentary trust avoids probate. It does not. A testamentary trust is created through a will, since the will is submitted to probate. The testamentary trust comes through the probate process. It may control distributions after death, but it does not avoid court supervision at the front end. The common thread in all of these myths is that people use words without understanding mechanisms. Will, trust, beneficiary, probate, power of attorney. These words sound familiar, so people think they understand them. But in money and law, familiarity is not competence. Competence comes from knowing which mechanism controls which asset at which time. Now let us talk about guardianship again, because this is one area where the will remains absolutely central. If you have minor children, a will is where you name a guardian. A trust cannot do that. A beneficiary designation cannot do that. An informal conversation with relatives cannot do that. The court ultimately appoints the guardian. But your will is where your wishes are formally expressed. If you do not have a will, you leave that decision to a court process with less guidance from you. For parents, that is a risk worth taking off the table. This is why the choice is often not will or trust. For many families, it is both. The trust can handle asset management and privacy. The will can name guardians and also catch assets that were not placed into the trust. That catch-all will is often called a pour. Over will, its role is to pour remaining probate assets into the trust after death. But remember, if assets go through a pour over will, they still may go through probate first. The goal is still to fund the trust during life wherever appropriate. Now, not everyone needs a trust. This is important because the goal is not to sell people the most complicated structure. The goal is to match the structure to the life. If someone has a simple estate, modest assets, clean beneficiary designations, no real property outside one state, and no major concerns about probate in their state, a well-drafted will may be enough. If most assets already pass by beneficiary designation, there may not be much left for probate. If the family dynamic is simple, and the person is comfortable with the probate process in that state, a will can serve as a solid baseline. Cost matter too. Trusts usually cost more to draft. They require more attention. Assets need to be retitled. The plan has to be maintained. If life changes, the structure may need updating. For some families, that extra structure is worth it. For others, it may be unnecessary. Estate planning should reflect assets, family dynamics, state law, privacy concerns, incapacity concerns, and goals. It should not be driven by fear. It should not be driven by someone else's checklist. It should not be driven by a vague belief that rich people have trusts. Therefore, everyone needs one. The right question is not, do smart people have trusts? The right question is, what problem am I trying to solve? If you are trying to avoid probate, a revocable living trust can help when it is funded. If you want privacy, a trust can help because probate is public and trust administration is generally private. If you own property in multiple states, a trust can help avoid multiple probate proceedings. If you worry about incapacity and want a loved one to step in quickly, a trust can be very useful. If you have blended family issues, children from a prior marriage, a second spouse, minor beneficiaries, or beneficiaries who should not receive assets all at once, a trust may provide the structure needed to avoid conflict and preserve intentions. Trusts shine when life is complex, and many lives are complex. A second marriage is complex. Minor children are complex. A child with poor financial judgment is complex. Real estate in multiple states is complex. Family conflict is complex. Privacy concerns are complex. In those situations, a simple will may not do enough, but simplicity also has value. If the situation is simple, a will may be sufficient. This is why I like to reduce the entire discussion to a mental model. A will equals death, probate, and public process. A will activates at death. It operates through probate. Once submitted, it can become part of the public record. That is not necessarily bad. It is just what it is. A revocable living trust equals life, incapacity, continuity, and privacy. It can operate while you are alive. It can allow a successor trustee to step in during incapacity. After death, it can allow assets to move privately if it was properly funded. That is the structural difference, but none of this works unless the details are aligned. Funding can matter more than the document. Beneficiary forms can matter more than the will. Title can defeat intention. Control affects taxation. Guardianship belongs in the will, and every adult should think about incapacity, not just death. I know this can feel uncomfortable because estate planning forces people to confront things they would rather avoid. Death, illness, family conflict, loss of control, but good planning is not pessimism. Good planning is the removal of unnecessary friction from an already hard moment. It is a way of protecting the people you love from confusion, court delay, public exposure, avoidable conflict, and mechanical outcomes that do not match your real wishes. The worst estate plans are not always the plans with no documents. Sometimes the worst plans are the ones where documents exist, but they do not work together. A will says one thing, a beneficiary form says another, a house title says something else, a trust exists, but is unfunded, a power of attorney is outdated. A healthcare directive is missing. The family assumes there is a plan because there is a binder. But a binder is not a plan. A plan is an integrated structure. I would approach this the way I approach any complex system. Start by mapping the assets for every major asset. Ask how it transfers. Does it transfer by beneficiary designation? Does it transfer by joint ownership or survivorship? Is it owned by a trust or will it fall into probate? Then ask what happens if you do not die. But you become unable to manage your affairs. Who can pay bills? Who can manage investments? Who can sell or refinance property if needed? Who can make medical decisions? Can they act immediately or do they need court permission? Then ask whether the outcome matches the intention. If the beneficiary on the retirement account is outdated, change it. If the house title creates the wrong result in a blended family, address it. If the trust is not funded, fund it. If minor children are involved, make sure guardians are named in a will. If privacy matters, consider whether probate exposure is acceptable. If estate taxes, creditors, Medicaid, or asset protection are concerns, understand that a revocable living trust may not be enough and that different tools may be needed. This is how to think clearly, not emotionally, not casually, not by assuming asset by asset, mechanism by mechanism, outcome by outcome. That is how you bring order to something that otherwise becomes painful and chaotic. At the end, wills and trusts are not competitors. In a simple contest, they are different tools. A will is simple, foundational, and essential for guardianship and probate direction. A revocable living trust is broader in administration. It can provide continuity, privacy, and probate avoidance when funded. An irrevocable trust is a more advanced tool that may provide tax or protection benefits, but only when control is given up and when the situation truly calls for it. None of them should be used blindly. The question is always the same. What problem does this tool solve, and what trade-off does it create? That is the disciplined way to think about estate planning. Most people think estate planning is about deciding who gets what. That is only one piece. The deeper question is how the system will execute when you are gone or unable to act. The legal system will not pause and ask your family what you probably meant. It will read the documents, it will read the title, it will read the beneficiary form, it will follow the structure. So the time to make the structure match the intention is now, while you are alive, competent, and able to think calmly. Because once the crisis happens, the system will move, and it will move according to what you built, not what you hoped.